all get paid done. So then it doesn't matter who's up there, it doesn't look at some. Because they didn't go with. Well, I need to bring it too.
We have look on the screen with us?
Yes.
Yeah.
Yeah. Right.
Oh, I think that's. I don't know what to tell you.
My chair.
You keep your chair.
I could hear you.
To try our best. You try to speak loud.
Okay, we hope you speak loud.
And you can ask us to speak up too if you need to.
Because I can't read everybody's lips are going like that. I don't know what you're saying.
So I can spit out my phone.
Yeah.
This is Mr. Chair. Well, it should be live streaming on YouTube. I just don't know why I think it's this. Sharon, can you confirm that it's live streaming?
No.
We'll get started in just a second here
Just a minute.
to make sure our live stream is operational.
I'll try.
Swell.
It is.
It is, and you
Yep.
can hear us delayed?
Yep.
All right, we are live. Well, I guess we don't need the TV, do we? I don't know why that's not working, but.
Oh, it is live. It is live. Loud and clear. Okay. Great job, Nathan.
Thank you. All right, we'll call this meeting to order. Roll call. Hager.
Present.
Hopperman. Present. Bernard present. Krasansky present. Burns absent, excused. Alternate Moore. Absent. We'll put unexcused at the moment. Correct that next time if necessary. Close. Present. Alternate close. All right. Seating of alternates as needed. I move that we seat Emery Close in place of Cassie Burns. I'll second that. A motion made by Bernard, seconded by Krasansky. All in favor?
Aye.
Opposed? Motion carries. Okay, Mr. Close, please join us. All right, Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Approval of the meeting agenda. I suggest a couple amendments to the agenda. Under 11, between 1 and 2, so A 1, 2, I would like to add the statement for the topic of conflict of interest. I'd like to do the same under B. And then I would like to modify number 3 under both A and B, the presentation by property owner. So motion to approve as amended.
Make a motion to approve those amendments. That you proposed.
The meeting agenda with the
Meeting agenda, which is conflict of interest and the property owners inputs.
Great, thank you.
I support.
A motion by Opperman, supported by Kager. Right, all in favor?
Aye.
Aye.
Motion carries. Great. Approval of the April 24th zoning board of appeals meeting minutes. For those, there's a modification that I would like under the ZBA member comments. It was mentioned that there was an update about renewable energy training made by Close. I'd like the record to reflect that Close and Opperman both received that training. Of 2 hours, is that correct? Okay. 2 hours. Help meet their training requirement. I'd like to make the motion to accept as amended.
I'll make a motion to accept.
I'll second that.
Motion by Kager, seconded by Kazansky. All in favor?
Aye.
Motion carries. The Millington Township policy for public comment. We do have many from the public today. Our public comment policy is up on the board. The very basics of it are you can speak 1 time per meeting. We have our regular meeting now, and then we do have 2 special meetings in this evening. Comment is limited to 3 minutes. All comments are to be directed at the chair or the zoning board of appeals. I think that would be the summary of it. Okay. All right, public comments regarding our regular meeting. There will be opportunity for the special meetings coming up.
Nice. Nice.
No.
Chat. Oh, that's sweet.
Yes, sir. You got the timer, sir?
Thank you. I can wait till I hand this helpful.
Yeah.
Let's just, do you have a paper copy of what? Thank you. Mashke, 7951, Houston Drive, Millington, also planning commission vice chairman. First off, I question why we're even here. As a planning commission member, Luann Tarzell had to recuse herself from voting due to conflict of interest during the planning commission review of the Tri-County aggregates facility. This same conflict of interest should have limited her input during the March 17th Millington Township meeting. However, Luann requested an agenda be updated, made motions, and voted on this issue despite a clear conflict of interest. As everyone is aware, Millington Township boards are currently under a lot of scrutiny. It is my belief that Luann is out of order, not only making the motion, but also voting to bring this to the zoning board of appeals. We must be confident that improprieties are not happening. With that in mind, I can also question Robert Bernard's need to evaluate if he has a conflict of interest regarding the SLUP for Tri-County aggregates as well. Robert has issued letters and spoken against the Tri-County Aggregates LLC during planning commission meetings in the past. Finally, several members of the planning commission asked to be on the agenda to give clarification and were denied. Our lawyer stated that our minutes will provide the information discussed in our meetings. With that in mind, I asked, why is the zoning administrator allowed to give a presentation as her views and comments would be provided in our meeting minutes as well? If some are allowed to speak, shouldn't all be allowed to speak? Thank you.
Thank you. Thank you. Yes, sir.
Richard, 9800 State Road, Millington. I would like to address the board about conflict of interest. I've contacted the MPA, which I have right here. This happens to be the one that's copied theirs, but I will be getting my own. But I think you need to read it. I'll review it. I have two different opinions. One from Attorney Mike Cox, one from Attorney General Frank Kelly, about conflicts of interest and members not recusing themselves and the consequences. So I would like to loan it to you and let you read it. I do want it back before the night though.
Are you talking about the MTA book?
Yes.
Okay, anything submitted, we will have to receive for public comment and have it included as part of the record.
You know what? That's fine, because I'm getting new ones tomorrow.
Okay.
And as far as these, I can always come with you, get more copies if I need.
Thank you.
This one is about the zoning board members. That is from Attorney General's. And we're talking about starts here, and goes here, and here.
2 pages. All right, thank you.
Yeah.
We need to read this now, aloud.
No,
I would.
they're accepted. Mr. Fletcher would like to read them within the 3 minutes.
I'm not a very good reader.
Thank you. Any others?
Gotcha.
All right. So there's no additional public comment in the room, so we will look at these. So I believe the letters, would they be appropriate under the special meeting, I would assume?
I would think so. Yes.
Okay, so we'll hold those for that period.
Yep.
Okay. All right, close public comment. Old business, there is none. New business, there is none. So I'd like to make a motion to close the regular meeting and open the public meeting regarding the special land use permit granted relating to parcel 0616-035-000-010010. Would you like to make that motion, sir?
I would like to make a motion to hold the regular meeting and go into the special meeting. Partial. I'll second.
Oh. Parcel as noted.
Yes.
Okay. Second.
Roll call.
Roll call. Hager, thank you. It's been a while since I've been here.
I know.
Hager,
Yes.
Opperman, Krasansky,
Yes.
Close,
Yes.
Bernard, yes. All right, seating of alternates, let the record reflect that we have already seated Mr. Close. And Mr. Moore has not arrived, correct? Okay. Conflict of interest.
The other. We got recipients, yes. Are you gonna discuss conflicts with youth?
Oh, I'm gonna bring that through. That's. Okay, so Mr. Opperman is unable to serve. There has been a packet submitted there's been a question raised. And there has been a packet submitted by Tri-County Aggregates. I was notified of it just prior to coming to this meeting. In which there is an argument made that I do have one. And that out to our participating members. This was in relation to a comment made at the October Planning Commission meeting. And then the other is the 2019 meeting as brought up by with information from Tri-County Aggregates.
Oh, thank you.
Thank you, sir.
Review.
Both of which include client attorney information, so please hold those in confidence. Both stapled items are separate decisions, one of which was, or opinions, one of which was given right as this appeal came in, and then another one as the information was received tonight. with the information provided, including submitted by Mr. Fletcher from the MTA guidelines, is consistent with our bylaws. Items which are required or just create a conflict is if the member is the applicant. I'm not. The applicant is close relative to the member. I am not. The applicant is a business associate or someone to whom the member is financially involved and the proposal could financial gain or loss. No. The applicant is for an appeal from a previous decision for which the member has recorded a vote. No, I do not serve on the planning commission or the board. The member's property is within the notice area. It is not. The reason why I brought this forward though was because a statement of the ordinance made at the October 10th planning commission meeting, which is included in the communications. And then also there was a packet submitted by Tri-County Aggregates today, purported a statement that was made in 2019, which was also about the ordinance, which is included in the communication, as well as the township attorney opinion on both. So I do not view that there is a conflict of interest for myself. However, the members of this board may deem that by majority vote. So I bring that to your attention just to make sure that everything is on the table.
I would like to speak. You brought up your information there, August 12th of 2019. You spoke there. Your wife spoke there at that meeting. You signed in, you have a sign up sheet with you and your wife. Pass on a letter from August 12th of 2019 of discussions about your views on this. October 10th, 2024, spoke in public comment 2 times regarding this Tri-County. Then in 2025, February 10th, your wife spoke on behalf of pertaining to Tri-County. We was having a meeting, and the meeting was concerning you. I was standing up there 4 or 5 times, sending a letter to the township of this matter and speaking on with the subject of yourself. And then I sat on a board. Should I be voting on that after I stood up there and talked 4 or 5 times and sent a letter in? I think it gives a real bad perception. That is my point of view.
Thank you. All 3 statements are included in the packets for spoken verbatim. That's all I'm saying about that. Is it's at the will of the board.
All 3 packets that you
Yes, all 3 times. All 3 that were mentioned, which was over.
was that this first packet?
There's 2 stapled in there.
Okay.
Yes. So there's October 2nd. September 23rd of 2019 and August 12th, 2019. All are included, as well as the attorney opinion on that. Because I made certain that I reached out just to make certain that any statements would not be an issue, because I did not want to put this board in jeopardy.
I will make a motion to include Bernard as part of the hearing without him having a conflict of interest. I don't know how else to word.
finish reading through the, I just want to,
Yeah.
yeah, I just want to make sure I get through here.
All three of those statements are in public record from those meetings.
It was.
Has been my experience of serving on this board that I can have a definite opinion about something, but when I sit here, my opinions don't count anymore. What counts is the ordinances and the legality of everything.
And that is what we are all bound to do. That is, of course, what I will do. And even reviewing everything submitted to the planning commission over those times, those have spoken to the ordinance and per the attorney. They concur that you have that information. But I'm at the will of this board. Do not want to create any kind.
Is there support for that? I made a motion.
I'll support it. I mean, I read through all this. It doesn't look like Robert said that he's, against the gravel pit. I mean, I'm trying to,
I
get
know.
through it all, but I'll second your motion. Yes.
Yeah. Yeah.
And we need a vote. So Fager,
Yes.
so motion, let me rephrase, motion by Fager. Where it is not a conflict of interest, seconded by Pizanski. Hager, yes. Close,
Yes.
Pizanski,
Yes.
and Opperman,
No.
okay. And since it's about me, I abstain.
There's a majority vote of the board.
Correct. All right, so I will remain seated and I will assure you that I will act in the best interest of the township, as well as strictly following the ordinance. Let's see. Thank you, sir. Okay. Comments, this is regarding the appeal by the Township Board of the Planning Commission's February 10th, 2025 decision of a commercial special land use permit relating to parcel 017 -035 -000 -0100 -10 Tri-County aggregates. So this is the commercial special land use.
There are two letters to read. Shall I read those first?
Please.
I don't know if they're both the same. From Lorraine Martin. I am asking you to revert the decision of the Planning Commission in their illegal approval of a commercial landscaping business at the Tri-County Aggregates gravel pit. This was approved with no regards for the ordinances or the wishes of the residents that live by the pit. A commercial landscaping business is not allowed in the ag residential zone, period. In attending meetings and listening to videos, not once have I heard the gentleman on that board even talk about considering what the residents want, or that they should follow the ordinance in regards to this special use permit. Residents have sent many letters or voiced their opinion at the meetings many times, yet the planning commission board ignores them. We have put up with the noise and the traffic from the kitchen. An illegal commercial business would generate a lot more traffic and noise, and that should not be allowed. Also, at the time of the approval, a reclamation plan was supposed to be submitted, and it wasn't, but it was approved anyway, then given 6 months to submit it. They approved a plan that was not in front of them to review. How is that the proper way to do business? Our ordinances are the township's law, and it was not followed. This should also be reversed. And I'm not sure whether the second letter to be read now or after.
Look at that now.
Okay, we may as well.
Apply to both.
It could. It just wasn't clear to me. To whom it may concern. I, Fred Line, was with Bill Stebbins in June of 2024. I think around the 18th of June, when we heard and felt 3 large explosions. The sound came from the southwest of the home, which is where the gravel pit is. Thank you.
Public comments. No, yeah. Come on forward. You can do the cheating, absolutely.
Okay, I'm gonna speak up loud enough. You all can hear me.
And if you can state your name, please.
William Stebbins.
Thank you.
How can I go on?
Yes, sir.
Okay, June 17 to the 19th. There was 3 explosions. I thought they were claymores at first, but I don't know how they would get claymores. So it had to be dynamite. One went off, it surprised me, me and my friend was outside. And then a few minutes later, I couldn't tell you the distance between them. Another one went off. And it was real. They can't use that kind of stuff. Then when the third one had come out, exploded, she came. And as she got out of the car, she couldn't believe it. So that's what I'm bringing up, explosions. That's all we do is eat dust. They ought to be paying us for it.
Sure. Come on forward, please.
I'll find
Okay.
Ina Mail, 10310 Sheridan Road.
I'm
And
sorry, did you sign in?
I did,
Then I will get it.
Ina Mail. And I hate to read to you, but I get passionate about this and that, so. But, for clarification, Dana Nessel is our Attorney General, but anyway. I agree with Mrs. Watton that we could reverse this decision. We're not following our ordinances. The taxpayers paid a lot of money for the ordinances, and the board, other than Luann, the commission, nobody agrees with the people that live around it. It's just the commission agrees with the pit owner, and I feel like we don't have a voice. And there's been multiple meetings, and it always seems to be the same thing. He wins. So I think we should follow our ordinances. We paid money for them. I don't think the planning commission should, with support of the township supervisor, be able to just change them on a whim to fit their narrative. I'm very puzzled by the motives. I'm also puzzled by you would bring unauthorized material from a commercial site, dump it in a residential zone, and then sell it commercially. That sounds like a government job, you know. I just can't emphasize enough that it's residential, it's agricultural. You know, the stuff that's being dumped in there, has it been tested? I don't know. I just feel like we don't have a voice and nobody's on our side. So I hope that you will. And I thank you for your time.
Thank you.
By listening.
Any others? Yes, ma'am.
Um, my name is Lynn Williams Johnson and I live at 9950 Sheridan Road. I've lived there for 4 years. And I'm about a half a second. My problem is when we had the meeting on February 10th and he was being zoned agriculture and residential. And then all of a sudden it's decided that he should be able to bring in landscaping goods, things like that, rock, whatever. And that totally goes against what the ordinance says. I believe that the planning commission should follow rules, follow the plan, follow the sections, follow the articles, and that's why I'm here tonight. Those were not followed when those decisions were made. And that is my biggest concern over what's happened. I also agree with the lady. How do you know what they're doing? What is it? It's not zone commercial. I'm not doing commercial. I don't plan on selling things from my home. I don't plan on selling anything from my land. I didn't ever buy that land expecting to put on a Marriott hotel and come to the zoning board and have it changed. We need to follow the ordinances that were set forth by the planning boards, and that's what we need to do. It has nothing to do with anyone else, any hard feelings, any this, any of that. We just need to follow the rules. Yes.
Thank you.
And Ted Mashke, 7951 Houston Drive, Millington, Michigan. Planning Commission Vice Chairman. First public hearing for this SLUP was October 10th, 2024. After public hearing and Planning Commission discussion, the consensus was that due to the open air sales of sand and other material, property needed to be in the Millington Township Commercial District per our section 10.02 our ordinances. Board was following ordinances. However, Mr. Gilling noted that he had documentation that previously Millington Township had been granted him with commercial status of this area. The Planning Commission Board tabled the discussion until additional information was presented. You can reference attachment 1, which is our meeting minutes. That's identified that we tabled it for a reason. Look at attachment 2 from Mr. Gilling, where the project is not to expect it to start for 15 years, 15 years per the document dated July 16th, 2027. And that's basically the recommendation process. Okay. Project has started. Reference section 3, the planning commission excerpt from June 20th, 2027, allowing the planning commission the discretion of allowing commercial enterprises within projected boundaries. Reference attachment 4 is an email from our attorney. In quote, in summary, the extent that the site condominium approval and continues remains valid after 17 years, the development of commercial enterprises within the projected boundaries is a matter within the discretion of the planning commission. Again, I'm going to quote that. The lawyer said that it's in the discretion of the planning commission, provided that the commercial enterprises are in a neighborhood type. He goes on to say the planning commission must determine whether the proposed open air sale of wood chips, zone creep, beach sand, and a commercial enterprise of the neighborhood type within the intent of the site condominium approval conditions allowed establish a commercial development within project boundaries. From the evidence provided in attachments, the attorney's feedback, the planning commission discussion, board feels we are within our discretion to approve this special land use permit.
That's fine. Thank you.
Mr. Maschke, are you speaking on behalf of yourself or on behalf of the planning commission?
We were voted that I could speak on behalf of the planning commission.
Speaking on behalf of the planning commission.
We weren't allowed to be part, we asked to be put on the agenda. We were denied, but I'm still, speaking as public comment, but yes, it's in our meeting minutes that I voted to represent the planning commission.
Thank you. Please let it note that this does include the current client information as submitted to the Millington Township. So I'm uncertain of how that is reflected in the public record. So members, please hold this in confidence until we receive correction.
Yeah, that's actually been read in full during our planning commission meeting. So it is already part of public communication.
Thank you. I have one question. Yes, sir.
Question. Yes. I was at the meeting there, and you were speaking on behalf of the planning commission, right?
Yes.
Right. Did you guys follow this, the procedures and processes for conditional use permits? Did you guys follow this? I know what you said. I know what you said in the board meeting, so I'm just wondering.
We go through those.
You followed this.
Best of my knowledge, yes.
Thank you.
Hang on a second. And it probably was just a misreading. In attachment number 2, you stated that I think it's also for your information is the site plan for the project dated June 20th, 2027, you said, I believe, but it was dated 2007 is what you have written here.
Yeah. Okay, did I say, well, in the document I gave you, June 20th, 2007 is incorrect. Did I say 2027?
No.
Yeah,
Yeah,
it's okay. You got it.
and I had another comment also on attachment number 3. What is 4? It says, in summary, to the extent that the site condominium approval and conditions remain valid after 17 years. We don't know that yet. The development is within the discretion of the planning commission. So that's an unknown. That's not a fact.
So in the document, those, I'll get to when we do the reclamation plan. Okay. It actually states that the recommendation was to start 10 to 15 years. There was no end date or no explanation.
But we have
think
not
that's
yet
gonna expire.
determined whether that remains valid. That's all I'm saying. Because that's the next public hearing.
Yes, the next one, yes. So
Okay.
that's, you know,
That's my
and I
point,
got,
that's all.
I have documentation to show that it has not expired.
That's fine, I'm just saying. But what's here is not exactly to the point. It's to the extent that it remains valid. So we don't know yet whether that's going to happen. That's all.
Thank you. Any other public comment? Yes, sir.
My name's Steve Lay, 7600 Osborne Drive, Millington. I didn't plan to speak tonight, but I stood here and I was at the meetings and I just got a few things I want to say. I agree that we must follow the ordinances, as everybody says. That's why we're here. We're not following the ordinances. We didn't follow all the procedures. We didn't look at all the hoops. We didn't dot the I, we didn't cross the T, we didn't ask the questions. Over 4.5 years ago, I was part of something I'm still part of. You know, this is a lawsuit of this township. We spent thousands of dollars of our money fighting a lawsuit that is again over the same issue. You're putting commercial operations, this planning commission is putting commercial operations in LR districts, in ag residential districts. You don't do that. You follow the ordinances. And that's why we're at the ZBA meeting. Because our planning commission can't seem to follow the ordinances. And now we have lawsuits, and we may have more lawsuits. And that's just foolish. Play our little games, talk about conflict of interest, like everybody's clean. There is so much evidence against what's been going on here. And here we are again, talking about a commercial operation in a situation where it should not be. I was at the planning commission meeting in October. He was there asking, the aggregate company was there, just had on their application, they wanted to re-up their application. They did not request to operate commercial entities out of their pit. It wasn't part of their application. That's actually something that came out of our planning commission board members. They brought it up. I sat there for 3 hours and listened to the crank. And it wasn't requested, it was something they were pushing. And so here we sat fighting something that shouldn't even been allowed. And it was generated by the planning commission again. And I'm just tired of, they're the ones that brought up this whole landscaping operation in the first place. It's zone agriculture, residential. Follow the damn ordinances, please. Thank you.
Any others? Yes, ma'am.
Lorraine Martin, 3445 on New Road. Well, I just, want to say the other part of this is yes, follow the ordinances. The Planning Commission, we've had many meetings over and over again. There's been residents that said letters, residents that are there voicing their opinion, and they not once look at our opinion. I mean, why should something be accepted by one individual that wants it when the many individuals don't want it? At some point, they should be listening to the residents that live in the township. And the planning commission does not.
That's right.
Thank you.
Way to go.
Sir, if you want to speak from there, but that would be acceptable.
A long chair, that's the problem with the net.
Ben Jensen, live on 9950 Sheridan Road. And I live on a hill and I see the gravel trucks go by. And I see every once in a while one with a cover over it. That means it's loaded with something going to the gravel pit, not coming from the gravel pit, but going to it. Another thing I'd like to say is I said here in the meeting and the board spoke their piece about how this should take place. And Mrs. Denzer was telling the board, you can't do that. That was like talking to this wall. Nobody listened. And it just, it's a shame that she puts her time in to help us and help you. And nobody wants to listen. And I feel that all the people that live in that area don't have any say. Nobody listens to them.
Nobody's listening.
Sir, thank you.
Any others? Move to close public comment. Yes, sir.
Matt Hopperman, you said on the planning commission also.
And I must ask, are you speaking on behalf of yourself or on behalf of the planning commission?
Planning commission. Sheridan Road is a Class A road. This gravel pit has been permitted since 1969, a gravel pit.
No, I haven't.
I seen that can be verified.
Just please direct that person.
That can be verified. In May 9th, 2007, Smith and Bowville, representing the township, met with the Southern Links Railway and also the township and the gravel pit itself. The members on this board for the township at that time was the chairman, Jay Kager, Paula Kavanaugh, Barry Green, Luann Jarzel, and Doyle Pletcher. I'll revert back to this right here about the information in this. The next day, there was a meeting at this township hall on May 10th, 2007, discussing all the information in that prior day. And it stated about a commercial enterprise along perimeter roads are permitted provided they are the neighborhood type. Also, June 20th stated the same similar stuff on it on June 20th about commercial enterprise by the board at the June 20th, 2007 meeting. Also, July 16th, 2007, board members again. The supervisor was Leo Allard, Paula Kavanaugh, Perry Green, Luann Jarzel, Doyle Pletcher, and Hager as a chairman, talking about the going through and what they were recommended about this same information, stating that they would refer back to the 2010 or May 10th meeting in 2007. Those notes. On the permit itself, the site permit, there's documentation right on the site permit of the individual of Tri-County. And it states commercial, local commercial on that right there too. Proposed uses, residential development with local commercial, states it right on there. There's also some other notes if you want to talk about his process and what he's supposed to do, what they agreed on, those board members are on that permit right there. Also, on July 8th, we had a board member talk to get legal advice for this planning commission that sat there and heard all the information from this. We had it said in as far as the attorney legal advice, it stated it was under the discretion of the planning commission. He stated this twice in the document about the planning commission and the discretion of the planning commission. Also, August 12th, 2024. There's information stating
Just to note, the Kager you referenced was my late one.
Okay, I don't know that. It was just on board.
Thanks for clarifying. There is no conflict.
Yeah.
Any final?
I say something else.
Only one, sir.
Only
Sorry.
once?
Yes. Great. Closed public comment. Presentation by property owner or designee. Yes, ma'am.
Members of the board, hi, my name is Jamie Nasidas. I'm here representing Tri-County Aggregates, the property owner.
Can you state your name for me again?
Jamie, Jamie, Nasidas, Nisisdis.
Okay, thank you.
Alright. And I understand you've already voted on the issue of the conflict of interest, but I just want to touch on one aspect of that, because that's going to come up again on the next appeal. So I want to point out that in the bylaws, one of the areas which constitutes conflict of interest, which Mr. Bernard did not read, is that if there's a reasonable appearance of a conflict of interest as determined by majority vote of the remaining the ZBA. So I think that's really what we're hanging our hat on here in terms of there being a conflict of interest in light of the statements that Mr. Bernard and his wife have made as it relates to Tri-County Aggregates operations, and particularly opposition to the very issue that's before this board tonight as it relates to the special use permit regarding the sale of the stone at the property. So it is our position that there is in fact a reasonable appearance of a conflict of interest, and for that reason, the vote should have been to find that Mr. Bernard has a conflict of interest and not able to participate here. I'll move on from that though, as you've already made that determination. We've raised another procedural issue in our submission, as well as it relates to how this appeal even is before the Zoning Board of Appeal. It was mentioned in one of the other comments earlier, which is that Ms. Jarzell determined that she had a conflict of interest on the Planning Commission, but then participated in the vote at the township level to bring this appeal. And we've cited in our submission how that in fact is a conflict of interest, and that makes that determination void. And it's our position that the township's decision to appeal is void and therefore not even properly before this Board of Appeals, and meaning that there's no jurisdiction to even decide this appeal. We cited a couple of Attorney General opinions in our submission that relate specifically to that issue. If you have a conflict of interest before one board, you certainly have a conflict of interest in acting on the same issue before another board. And she determined that she had a conflict of interest before the Planning Commission, so therefore she also had a conflict of interest when voting on the appeal with the Township Board, and in fact making that motion. So for that reason, it's our position that the ZBA should not even hear this appeal. With regard to the substance of the appeal, I'm just going to reiterate some of the comments that were made by members of the Planning Commission. So this operation has been in existence pursuant to a special use permit, at least with Tri-County Aggregate, since 2005 at least. And that special use permit has been renewed on every occasion, including as recently as August of 2024. And each time the same conditions, the same requirements have been included in that special use permit as that has been approved and extended. And specifically in 2007, the Planning Commission determined that commercial enterprises within the project boundaries were acceptable as permitted uses within the Planning Commission's discretion. And so the Planning Commission, as others have stated, had discretion to allow, pursuant to a special use permit, as they did, commercial enterprises within the project boundaries. That is sort of the law as it applies to this property, because it's grandfathered in. So what the ordinance says now isn't what matters. What matters is what is the law as it relates to this property and the decisions that have previously been made as to this property. And the decision previously made and not appealed was that commercial enterprises are allowed within the discretion of the Planning Commission. And a discretionary decision is exactly that, within their discretion. So when you're on appeal from a discretionary decision, the most amount of deference is applied to that decision. So a reversal can only take place if there was an abuse of discretion. It's not something where the Zoning Board of Appeals can just decide it anew. There are different standards of review when you're dealing with appeals, and that a discretionary decision is the one that provides the most deference to the entity that made the original decision. And in this case, for that reason, it is our position that the decision of the Planning Commission on the special use permit should be affirmed. It was within their discretion. And we cited in our brief some of the same materials that have already been spoken to today as it relates to other people's public comments, the opinion of the attorney, for example, as well as the minutes from 2007 that specifically identified the permitted uses. So those are an exhibit to our submission as well. And with regard to the issue of it not having yet been determined that the reclamation plan is valid, obviously, it's our position that the reclamation plan was in fact approved as part of the special use permit for the gravel operation back in August of 2024, when it was extended. And that again, that issue was really not properly before the ZBA. We'll make that argument when we get to the next portion of it. But there is no expiration to that. The development portion of that, which I think was what Mr. Opperman was trying to state at the end of his public comments, that there's a time period in which they can develop, but there's no end date that says if you don't develop by this date, that the right to those permitted uses don't. If that makes sense.
Are you referring to the site plan in that statement?
Yes. Yeah, our exhibit, let's see, exhibit M to our submission, which has a list. Yeah, has a list of permitted uses, one of which is the establishment of commercial enterprises within the project boundaries shall be at the discretion of the planning commission.
And which exhibit was that again, please?
Exhibit M to our submission. M as in man.
Okay, thank you.
Any questions? I'm happy to answer any questions.
No, then yeah.
All right, thank
Thank you. Okay, presentation by zoning administrator who is actually speaking on behalf of the township board. Is that accurate?
Yes, the board voted to have me speak on the reach.
All right, Tony, you don't answer it, but. All right, Bob, this next one.
Here's a, before I actually get into what I have prepared tonight on behalf of the board, I just want to make a clarifying statement. There's, according to our ordinance, when it comes to a mining operation, kind of like a three-legged stool. You have the special land use permit, you have the site plan, you have the reclamation plan. And it takes all three of those things to be reviewed and approved in order for you to have a proper mining operation in accordance with our ordinance. When we talk about the commercial enterprises within the project boundaries, that was a note that was placed on the reclamation plan back in 2005, 2007, when it was originally approved. That reclamation plan was not reviewed and approved in 2012 or reviewed and approved in 2024, which will be part of our conversations that we'll have at the second appeal hearing. But that notice about the commercial enterprises being within the planning commission's discretion is relevant to the reclamation plan. Today, we're talking about the special land use permit. That being said, I have provided you with a copy of my report that was part of the packet that the chair sent to everyone.
And that's on,
Sorry.
that's on page 23 of your packet. Right? That's where it begins.
So I'm only going to read it in part. This report is submitted on behalf of the Millington Township Board to the Zoning Board of Appeals in relation to the special land use permit granted to Tri-County Aggregates for the resale of sand and other materials. The board respectfully requests that the Zoning Board of Appeals determine whether the activities in question is a permitted use, either by right or by special approval, within the agricultural residential zoning district in which the property is located. The purpose of this report is to provide the Zoning Board of Appeals with relevant ordinance references, statutory guidance, and supporting documentation to aid in making an informed and legally sound decision. On February 10th, 2025, the Planning Commission approved a special land use permit allowing Tri-County Aggregate to conduct resale of materials on that site. The property in question is zoned agricultural residential. The ordinance is clear per section 4.03 that any use not expressly listed as a permitted or special land use within the zoning district is prohibited. On February 21st, 2025, the Millington Township Board filed an appeal of the special land use permit citing inconsistency with zoning requirements. As stated in the township's notice to Tri-County Aggregate, the special land use permit is held in abeyance, which stays all proceedings, meaning the permit or the special land use request in the permit cannot be acted upon during the appeal. According to the Millington Township zoning ordinance section 10.02A, the resale of materials conducted partially or entirely outdoors is only permitted through a special land use permit in the commercial district.
This provision does not extend to the agricultural residential district. The agricultural residential district allows the following uses, either by right or by special approval in zoning ordinance Article 5. Section 5.01 allows farming, single-family dwellings, small-scale agriculture business, and certain home occupations. Section 5.02 allows special land uses, including campgrounds, schools, churches, kennels, and quarrying operations, subject to the strict reclamation and site plan conditions that are found under Section 5.03. Notably absent from this list is any allowance for retail resale of materials, which would include those sourced from off-site or stockpiles for commercial distribution. Tri-County Aggregate may have an approved quarrying operation under Section 5.03, but this approval is not a license for resale of material. Resale, especially of material not generated on site, constitutes a separate commercial activity. Section 10.02A confines this activity to the commercial district. This activity is not listed as a permitted use either by right or by special approval in the agricultural residential district. The Planning Commission's approval of the special land use permit may conflict with several core provisions of the Michigan Zoning Enabling Act. If the resale of materials is a commercial activity permitted only in the commercial district, then allowing this in the agricultural residential district may violate the intent and structure of the zoning ordinance and undermine the public planning process. A special land use permit cannot be used as a tool to permit a use not otherwise authorized in the zoning ordinance. Doing so would effectively circumvent proper rezoning procedures and would exceed the Planning Commission's authority. The zoning ordinance explicitly prohibits unlisted use in a district unless specifically approved. If the Planning Commission's approval of a special land use permit for an activity not listed in the agricultural residential district, the Planning Commission may have acted outside the bounds of the ordinance's enforcement framework. Such approval would be viewed as inconsistent with the Michigan Zoning Enabling Act, which requires that all zoning administration and enforcement actions adhere strictly to the procedures adopted in the ordinance. As a result, we respectfully ask that the Zoning Board of Appeals decide on the following. Number one, whether the resale of sand and other materials is a permitted use, either by right or by special approval within the agricultural residential district. Number two, whether the Planning Commission's decision to grant a special land use permit for this activity exceeded the authority granted under the Millington Township zoning ordinance and the Michigan Zoning Enabling Act. If the Zoning Board of Appeals should determine that the resale of sand and other materials is not a permitted use, either by right or by special approval within the agricultural residential district, and that the Planning Commission's decision to grant this special land use permit did in fact exceed the authority granted to them under the Michigan Zoning Enabling Act and the Michigan Township zoning ordinance, then the board respectfully requests that the Zoning Board of Appeals reverse the Planning Commission's approval of this special land use permit. Do you have any questions for me?
Was this reviewed by the township board? Your report?
The report that I just gave you?
Yep.
No. What's that?
When did you make this report?
When did I type it?
What date did you generate this?
I
Did you
can't
create it?
say for certain.
No. Well, I'm just looking at the appeal. And the appeal, it states the nature of the request. And it seems like at the end of it, different.
Right.
It was shared with the group as part of the packet.
I think the
Seven.
request was consistent with the appeal, but.
Yeah, it's not consistent in that it does not state the parcel number. So if a motion is made, we need to make a motion that includes what the appeal is.
I guess I'm not following. You want my report to reflect the parcel number?
No, it's at the end of your report, it says you're asking us to decide two things. right?
Well, no, so the appeal asks you to decide whether this special land use permit should be reversed. My report gives you the basis on which you would reverse it. Does that clarify?
Again, it says if the ZBA should determine that the resale is not permitted. Then this should happen.
Any other questions?
The zoning administrator, what is the zoning of this property?
It's zone agricultural residential.
Has this property ever been rezoned?
It is not.
Thank you.
Any other questions?
Thank you.
See them submitted by. Was it?
You're asking a lot.
Hopefully it was the one with the binder cover. This packet was submitted as part of the record by legal counsel for Tri-County Aggregates that was submitted today. There's only one copy. I was notified immediately prior to the meeting that it was here. I guess over an hour.
I can make copies if you're looking to. Oh,
It's 77 pages. Great, so we are on to discussion and action. They're gonna deliberate and talk about. I get good. They're gonna deliberate and talk about it. I agree.
Now, I get it's a discretionary opinion that planning commission made to allow this. But can the planning commission override the ordinances without any consideration of them? Because I have not heard any consideration of the ordinance when it strictly says the business has to be in a commercial district, and this is an ag residential.
Going to the commercial enterprise that was referenced by Tri-County Council, as well as in the appeal. That decision, actually based on what I see, which is on page 44 and 45 of the packet, that is the reference decision from the planning commission, including site plan. Number one, even on the site plan, it states current zoning is agriculture.
when they had a proposal. On page 45 was their decision. That decision, even at that time, I believe was outside their authority because they're including R1, R2, and commercial enterprise in that decision. The property was clearly zoned to agriculture. Additionally, Ms. Denzer stated that it was a site plan and reclamation plan. Is that accurate?
It depends on where you're talking. So there was a site plan and reclamation plan that was approved in 2007. Since then, we've had a special land use permit and a site plan that has been reviewed and approved. I don't have those dates in front of me.
2012 said something.
And 24.
Yeah.
But the reclamation plan was not revisited during those review processes. That's something that we discovered after the fact, which was the reason, as Mashke explained earlier, that the planning commission tabled it was to investigate that further. That being said, as I noted earlier, the note about commercial enterprises being allowed if they're of the neighboring type, and I might not be quoting that exact, that was written on that original reclamation plan from 2007. It is not written on any of the subsequent documents.
And I see nothing from them even referring to a reclamation plan when I look at 44 and 45. So I can't find evidence of the reclamation plan even, but I do see the site plan and I see even their statement. The Millington Township Planning Commission has reviewed the Cedar Lakes Estates site plan dated May 10th, 2007. And it goes on from there. That's on page 45 of our packet. That was their motion. And then I look at the document that was included in that states on page 44, site plan. That's what was being referred to, and their notes indicate motion. However, if I go back and I look when this was originally done, I believe it's 2003. Is that when this? If you look at pages 35 on forward, which has images of this, and then you start at 33, where's the cover sheet? And that cover sheet moves on to general plan, south area mining, north area mining, south area reclamation, north area reclamation, overall reclamation plan. Looking in, it's there and it's very detailed. I don't know if it would match our current 2020 ordinance. But it's all there, including page 40, where it's blown up on reclamation plan notes. So they mention it very well at that point in history. Though you move to 2007, and it's only mentioned as site plan, including a submitted document. You look at 41, 42, 43, and then the most current documents. So we're not onto reclamation plan, though what seems to have awarded any use for commercial enterprise was that motion. 2007, as noted by Mr. Mashke, Mr. Opperman, Ms. Denzer, and TCA Council. The attorney guidance, which was mentioned by Mr. Mackey, but also has been attorney-client privilege information that's shared with all of you. I do have one copy available if you'd like to review again. It mentions the approval, and if it's still valid. And that. I'm not sure. I would have. Absolutely. That's, yeah, again, it's fair perhaps. And I do have, if anybody has. I've shared it with all of you as well as the planning commission members that requested to be on the agenda. I have the attorney opinion. All detail available, but I did share that with each of you as well. But that one right there is regarding this. This document mentions a controlling ordinance from 2002 and the amendment from 2006. We don't have grandfathered in ordinance as far as.
No.
No. And if we look at page 58 in our packet, section 17.03 of the 2006 amendment that specifically mentioned in their ruling states site plan approval expires if construction fails to commence within 1 year following approval. It has not. They've been running a quarry ever since. They have not completed reclamation. So I don't think that site plan has been valid since like 2008. And then additionally, on page 60, the 2020 ordinance reads 24.02, former Millington Township zoning ordinance adopted on the 30th day of September 2002, and all amendments thereto are hereby repealed in their entirety. And which validates that we are to follow this current ordinance and this one only. I don't know if there's an argument of what the zoning of the property is, because everywhere it points to is AR. The permit application submitted by Tri-County Aggregates on page 6 says AR. The drawing submitted as part of that application, current zoning AR. Zoning map on the wall, which is also in our ordinance, shows it's AR. And the fact that it's quarry, which is only permitted in AR. So I don't think that that's much of a question, at least to me. I think the question is can they permit this use within that district?
I think all of this boils down to AR versus commercial. It's not a commercial district. It's an AR district, and it's not allowed in an AR.
Even, you're talking about that, reading through, so just on that same line right here. it specifically says right here. And she's got, gardening. This is all stuff that's not allowed. Correct. Lawyer calls it over here.
That makes reference to page 45 of their motion in 2007. It is not to include nursery stock. Right. Steel fertilizer, which I questioned if they were even within their authority to make the statement of commercial enterprises, because the property, according to all of our records, Ms. Denzer, has never been rezoned. It's never been granted commercial zone. That would be necessary.
What is it? I was reading, so. No.
Don't think the proposed uses are really of a neighborhood type either.
You go under 10.02.A, it's page 19 of the ordinance. The special land use for commercial district, which is open air business such as drive-in theaters, fuel and propane sales, racetracks, used car sales, farm machinery sales, outdoor recreation facilities, or any retail businesses which are conducted entirely or partially outside an enclosed building. And that's a special land use under commercial in itself. That's not even by right. And the plan that was submitted, even, you go under page 15 of the current ordinance, it matches 6.02.5.1.8, or it's 0.2. But as you go in there, that would be condominium plan to be submitted for review pursuant to the articles of the standards of Article 17 of this ordinance and Section 66 of the Michigan Condominium Act. This is the preliminary review, which includes items A, B, and C. So survey of the site, plan delineating all natural features on the site, including but not limited to ponds, streams, lakes, springs, floodplains, wetlands, and woodland areas. Location, size, shape, area, width of all condominium units. Now, granted, when that decision was made, this was not the ordinance, it was the 2006, right? However, as we know, we have to follow the current ordinance. I mean, it seems that the planning commission kept confusing that issue as to what ordinance they were trying to follow, if any.
Robert, are we gonna talk about the Luann Zarzell's conflict of interest on this whole thing and the appeal itself being filed? Or if the motion was made by, I'm just trying to read through this packet that we got from the property owner. And it says during the planning commission meeting, the planning commission voted that Luann Zarzell was deemed to have a conflict of interest concerning TCA's operations. Attached here to and incorporated herein is Exhibit J that says during the planning commission meeting minutes, Zarzell was not permitted to vote on any matters concerning TCA. Zarzell serves on the planning commission as a representative of the Millington Township Board of Trustees. On February 17th, during the board trustees meeting, Jarzell made a motion and voted in favor of appealing the planning commission's decision to approve a reclamation plan. I don't think we've talked about this, Chad. I mean, it's,
I do have attorney-client privilege information, which is just handing it right there. I only had minutes to review what was there. I did immediately seek counsel.
so. Which one of these attorney general opinions is it citing in this? You don't know?
That is what I received.
Okay. Well, that's interesting.
So if we do have an option of not making a decision this evening, leaving that under old business at a future meeting. If we need to reach out for more legal counsel, you do that through the zoning administrator.
Well, I guess my question on that is, yes, she had a conflict of interest. Planning commission, your conflict of interest we're talking about, and she didn't vote or anything, right?
Not on the planning commission. That's what it says.
Right.
Is on the township.
Or
Was that discussing the verdict?
It was discussing making an appeal.
yeah, she
An appeal.
says she filed the or she made the motion and voted in favor of appealing the planning commission's decision to approve the TCA's reclamation plan and permanent application for bringing in aggregate and landscape supply. So it says Luann Jarzell is the one who made the motion and voted in favor of it.
Can you read that whole thing again for me, please?
It says on February 17th, 2025, during a board of trustee meeting, Jarzell made a motion and voted in favor of appealing the planning commission's decision to approve TCA's reclamation plan and permit application for bringing in aggregate and landscape supplies for local community sales
Okay,
to the ZBA. So she is the one on the township board that made the motion
both, to appeal both.
for both.
That's what I didn't get the first time you read it. So, thank you.
Yeah, and I think
Sounded like
she's
there's-
within the notification zone,
Yes.
right?
She could not serve on
Mhm.
the planning commission. No, the role to be the liaison through both, from the planning commission to the board, that is her duty. That is her point of the meeting.
To make the motion to appeal it, I just,
And the vote,
I mean,
I
Matt,
believe, was 4 in favor.
he's not even allowed to
In
sit
one-
up here, you know what I mean, for our decision or deliberation. She had a conflict of interest that was obvious to everybody, and she made the motion and then voted on it. She's in the notification zone.
And what was the vote? Yes and no. How many?
I don't know, I haven't got
It
that
was
far.
4 to
Okay.
4-1.
correct. At least per my recollection.
I mean, that seems like a pretty big part of this from the property owner. That's the whole point they're making.
It is, but if 3 other members besides Lynn voted to approve that, but her vote wouldn't count, let's say. It would have passed without her vote. Yes.
I don't know if anybody would have made the motion.
That's what I was just gonna say.
Right,
The motion's another story, but
And as far as we follow, the Michigan Zoning Enabling Act speaks clearly. A member of the zoning board of appeals who is also a member of the zoning commission, the planning commission, or legislative body shall not participate in a public hearing for on or vote in the same matter that the member voted on is a member of the zoning commission, planning commission, or legislative body. Which is why planning commission member was withhold from these discussions and revisions. If I recall correctly, for the planning commission, the planning enabling act, I do not have a copy here, so I believe for them, the shall not participate was not included in that. It was a vote. But I don't think that that's really the question here. Conflict. If the planning commission, since clearly declares that. On the board level, I don't know, the planning enabling act would affect that, as it's a very different role at that point. That point, we're dealing with trustee. So it certainly is a question.
well,
no, definitely is, yeah.
if it is decided that the motion made in the township board was not correct, that means we're sitting here twiddling our thumbs,
Sure.
which is a waste of time, of everybody's time. Except we're learning something. Never a waste of time. But I think it would be proper to go ahead with the meeting as planned, then get legal advice as to whether that motion to appeal is valid or it's not valid.
Based on the advice given, I'm not sure if we will clearly get that answer. It may be up for the courts to decide.
So do we pack up and go home, or do we continue?
Well, I think it's very rare in all of the Michigan Township Association's guidance that, and we even brought it up at the last training. Somebody brought it up at the last training and asked about a board appealing, the township board appealing the planning commission, and it doesn't happen. It's extremely rare.
Right.
In Millington Township, we've done it twice in less than a year. So that's an issue too.
I think there's an issue with the planning commission following the ordinance, though. I think that's probably the bigger issue. The township board, though, doing the administrative appeals, though, those should be very few and far between.
I think so.
Because the decisions should be based on the ordinance. And that is a question brought to us through that appeal.
Well, the question I have is, I don't understand why Luann didn't appeal it herself. Why did she appeal it through the township board? That is a question that I have. It seems anyone can appeal anything.
The 4 members of the board, when they 4 elected members of that board went in favor of it, which I think speaks volumes to what we're viewing here.
Mm-hmm. I don't understand how they didn't see the conflict of interest at that time when the motion was made.
Would be a conflict, but that would be to their own bylaws. Because we can only deal with ours, which the appeal was not made regarding a conflict of interest. The appeal was made about whether this follows the ordinance or not. So whether the planning commission acted within their authority. So I'm at a loss there. Fact that it was a 4-1 vote. I think that does speak quite a bit too.
These were by elected officials, not appointed. That's huge.
Public.
I just.
Yep.
I just, it wouldn't be 4-1 either.
Pardon me? No, we're not a public action.
Well, I just wanted to, I mean, I'm trying to read through this
I know, that's a
77
big
pages.
concern.
I mean, that's right in that's like their whole argument is that the Millington Township Zoning Board of Appeals cannot hear this appeal because the motion to appeal was improper. I mean, it's a very good point. It's valid. And I don't know if we should.
We can also seek legal counsel, as that was received by us just this evening, that lengthy statement.
I just think what would the judge think? Do you know what I'm saying? If they look at all these documents we have and they review, I mean, she's in the notification zone. She has a clear conflict of interest. She made the motion and voted on it when she's recused herself from her planning commission duties to do the same. So
Disciplining enabling act requires her to do so. It don't go on the trustee. Well, so what we could do is we could delay this decision until our next meeting. And have legal counsel available for full session. To go over that specific issue is, it certainly is a legal question.
Would you like a motion?
I would motion that. I think we should make a motion to seek, further information on this.
Right. I would make a motion to delay a decision on this until we have legal counsel advice regarding conflict of interest.
I'll second it.
Okay.
But you got your hand right.
I mean, what do you do with that? That's
On both of these items.
Well, we can't. We can only do one at a time.
Okay.
Yeah.
Okay.
So we go through the process. Okay, so would you please read back the motion, Ms. Hager?
I'm trying to write it.
Okay, we're gonna go.
Okay, I make a motion to delay a decision on this item until we have a legal opinion on the validity of the appeal. What? Appeal. On the validity of the appeal. Thank you.
It would be a legal decision. So
All
we will
right.
hold that at a future meeting with.
We'll have that.
counsel.
It will have to be a public hearing, right?
Correct. We can do a closed session with the attorney though, so we
Okay.
can hold a regular meeting. A
Okay.
closed session with the attorney. And then
And then-
under new business, make a decision.
Okay, because we have all the information on this one.
Correct. We close the
Right.
public hearing. Yes, sir. Oh, wait a minute. We have a motion on the
You seconded. Oh,
motion by
okay.
Kager, seconded by Zansky. Any discussion?
how quick can we do this?
Yeah.
I'm being serious because everybody's waiting. There's people waiting everywhere. We've already tied this up for how long because of this case. This needs to be resolved.
It can't be any quicker than 2 weeks because of public notices, so it would be.
Right.
We don't have the public hearing notice though, with the publication. It doesn't fall under the special meeting. But we would have to review that time, but 2 weeks is probably most probable that it's when we have a date established and are able to schedule the attorney to be present for a session. Okay, any other discussion?
I mean, we also have the 77-page packet that, you know, what I mean, was last minute.
To give you plenty of time to review.
Yeah, I don't think any of us have time to sit here and read the entire.
Not
packet.
tonight, yeah.
Correct.
But it says that would be nice to have that, you know,
Right.
prior.
At least a week ago, yes. But they're certainly within their rights and how it was submitted. Okay. So. Motion made by Kager, seconded by Pedanski. We'll do a roll call vote on that. Pedanski,
Yes.
Close,
Yes.
Kager,
Yes.
and Bernard, yes. So motion carries. We have a motion to close this special meeting and move to our next.
I make a motion to close the meeting, close the special meeting.
We make it 2 and 1. Close the public meeting and return to the public, close the public hearing and return to the public meeting.
Return to.
No, okay, I'm sorry, the other way.
You make the motions.
No.
Okay, motion to close the special meeting made by Close,
I'll second that.
seconded by Pedanski. This will do roll call. Kager,
Yes.
Close.
Yes.
Pedanski.
Yes.
Bernard, yes. Okay. All right, moving on. Motion to. Actually, Ms. Kager, would you be willing to? You've got the parliamentary procedure.
I will make a motion to open. Where is it? To open the public hearing related to the reclamation plan approved by the planning commission regarding parcel 017-035 000-0100 110.
Seconded by Close, motion by Kager. Any discussion? Okay. All in favor?
Aye.
Aye.
Carries. Okay, seating of alternates as needed. Please let the record reflect that Mr. Close has been seated as alternate. Conflict of interest. Mr. Opperman has already removed himself as a planning commission member. And the record that has been submitted to record is regarding the questions of my own. So I do not perceive a conflict of interest for myself. However, I certainly put myself at the will of this board.
I am fine. Because I know you follow the ordinances and not. Yeah, so that's a feel. It's not your opinion. The ordinances.
And we do not necessarily need a motion, though. I guess that would be best. It's been brought up several times, so I guess that should be in
Did
record.
we do it
You did a motion for the previous. one.
Okay. All right, I will make a motion that Bernard is not does not have a conflict of interest in this matter. And may I
A second. Discussion? Roll call. Zamsky,
Aye.
Close. Aye. Hager,
yes.
and of course I will abstain. It's pertaining to me. All right, moving on to public comment. This is in relation to the reclamation plan appeal. We do not have any unique special letters for this one. Is there any public comment? Yes, sir. Sir. Thank you.
Okay. Ed Mansky, 7951 Houston Drive, Millington, Michigan. Also, Planning Commission Vice Chairman. On February 10th, 2025, Planning Commission approved an extension of the original site plan reclamation. And I'm gonna note right here, you see in parentheses, it says reclamation / site plan. That is actually on the blueprint documents. So when we talk site plan and reclamation plan, they're the same thing. They're in the same exact. Okay, let's note that. That was unanimously recommended and approved by the Planning Commission on July 16th, 2007. Reference attachment 1. Also noted that this document references that the implementation is not expected to commence start for approximately 10 to 15 years. There is no completion or planned expiration date noted. Mr. Gilling has invited the board members to review the reclamation work that has already been done over the past years already. I and several other board members have been there and seen the work that is already started. In attachment 2, item 1, the controlling ordinance shall be the Millington Township zoning ordinance 02-03 dated September 30th, 2002, including amendment number 1. They're updated November 20th, 2006. The site plan development, again, reclamation / site plan, is supporting the documentation of the original Tri-County Aggregate Incorporated SLUP for sand and gravel mining operations. The existing SLUP extension that was granted on October 10th, 2012, and went into effect on December 2nd, 2015, and is a 10-year extension expiring on December 2nd, 2025. So the current mining operations are still within the existing approvals, reference attachment 3 and 4. Planning Commission was informed by multiple people, including the zoning administrator, multiple times that we were approving an extension of the existing plan, not a new plan. Planning Commission reviewed the plan that was provided and compared it back to the previous and noted some differences. The motion that the Planning Commission made and approved was based on keeping the reclamation / site plan in line with the original plan. Yep.
Thank you. And are you speaking on behalf of yourself or on behalf of the planning?
On behalf of the Planning Commission, because we have voted on it.
Thank you. 1 second to make sure. All right. Any other public comment?
Can I just ask a question? We can't,
We don't necessarily respond to questions, but you may speak. Please state your name.
Rhonda Benson, I live at 9950 Sheridan Road. Now, when they talk about this reclamation plan and the years that prior when it was established, like 2007, I guess they're selling 17. And he's purchased other properties adjacent to this. Does that reclamation plan that they say they're going to extend, does that only evolve, does that only take in that one property description? Or does it encompass the ones that adjoin to go? Does that make sense? You know, like say the one property ends in 00 and then the next one's gonna end in another number. Is that reclamation plan for the original parcel that he purchased? Or is he enveloping it into the other parcel?
It is a specific parcel. And I don't know if that parcel, that specific parcel encompasses any additions since the 2002. But what we're talking about is 017, 035, 000, 0100 -10. That's the parcel that's in question. I don't,
you know,
I do know what you're saying, but
because I didn't know if you have to do more or the more you find for different parcels.
Also be noted on the application. Yeah, permits should include those parcel numbers or number. Okay. Other public comment. Okay, public.
I got some. Sir. Matt, operator of the planning commission. I'm going to refer back to the May 2007 document from the township here. It's talking about the controlling ordinances being number 0203 dated September 30th of 2006, including amendment number 1 dated November 20th of 2006. There's all 3 documents state the same thing that the board voted on is that. Also, pardon me.
is that at which time?
The board voted,
What?
the one document says June 20th, one document says July 16th, and the other document is from May 10th. Also, we've seen some variations in his site plan that Mr. Gillings actually said that he agrees to correct them, putting them back to the 2002 or 2007 site plan that he had submitted. We made corrections on that after we looked at the reclamation plan. And those were removed, number 8, 10, and 11. He agreed to all of them. Also, in the one document dated that July 16, 2007 said, as a current envisioned implementation, this project is not to expect to commence for 10 to 15 years in this document that was given to the township also. In the documentations also in 503 decisions permits, if the individual, the special land use permit has no written violations that occur, then they would automatically, that the permit shall not be revoked. Also, the last 3 township supervisors that's been at this township has not had one written complaint of this individual, not one.
However, the appeal here was over a reclamation plan, not over the special land use plan. Is that correct? That was your
This is
decision.
about the recommendations plan.
Clearly not about the special land use plan. So the mining permit
Was already done in 2024. I think August, don't quote me on the month, but it was done in 2024, that aspect, yes, sir.
okay.
I just wanted to state some of these things. We actually, we talked in the 503C about a reclamation plans and the standards. We talked about that when we were looking at this very closely. And then we made a statement that we would, we're gonna give them time. Okay, sorry, I gotta see what.
Chair, yes, I was.
Also, we said that we would approve this with the condition that the site plan, reclamation plan, would be submitted to Millington Township no later than August 11th of 2025. Because it was stated by Mr. Dillon that it would take approximately 3-4 months to be able to develop a new site plan. Also, the one board member, Jarzel, was very concerned about the new plan and wanted to make sure that it would viewed as being up to date. That is in the February 10th minutes. And also the voting that she said that she had a conflict of interest is in the February 10th meeting, also on the 10th. That's all I have.
Thank you, sir. Yeah. Other public comment.
Thank you.
More public comment? Public comment? Moving on to presentation by property owner.
Thank you. Jamie Nisbitis, on behalf of the property owner Tri-County Aggregates. To make my record, I'm going to address the issues we discussed in the prior appeal as well, just so that it's in the record. As you know, we have raised the issue of Mr. Bernard's a conflict of interest and that he should have been disqualified from hearing both of these appeals based on prior statements made at planning commission meetings that were in opposition to this particular operation by Tri-County Aggregates. And we've also cited to the fact that there is a reasonable appearance of a conflict of interest, which is what is set forth in this board's bylaws as one of the bases for finding a conflict of interest. We're also again raising Ms. Jarzel's conduct at the township board meeting and having a conflict of interest and having still voted, actually moved and voted to approve this appeal to the zoning board of appeals. And for that reason, we believe that the appeal is invalid. With regard to the other issue that we raised in our written submission, I would like to state that Mr. Gilling has been very cooperative with the Planning Commission in its desire and request for him to provide a supplemental or updated site plan. But it's our position that the reclamation plan that is at issue in this appeal was approved back in August of 2024. And if there would have been an appeal from that approval, that appeal is now time-barred. You had to appeal within 30 days of that final decision, and we set forth in our submission how in fact that did not occur. If you look at Exhibit E in our submission, that is the August 12th, 2024 meeting minutes of the Millington Township Planning Commission, a special use hearing on that date. And the second page of those minutes specifically states in talking about the special use permit that was renewed at that time, that the reclamation plan Cedar Lakes Estate was reviewed by the commission and meets the requirements of the ordinance. That was part of the motion that was approved, and it's our position that as a result, that was something that became final after those minutes were approved on September 9th of 2024, and the special use permit was renewed at that time. This appeal was not filed until February 21st of 2025, well after the approval of the reclamation plan. So again, Mr. Gilling was trying to be cooperative with the Planning Commission's desire for there to be a new site plan submitted, and that was this site plan / reclamation plan submitted that they voted on at the February meeting. But that plan had already been approved back in August and then made final by the approval of the minutes in September. So again, it is our position that this is not for the zoning. Thank you. And I guess I'd also note too, to the extent that the planning commission sought to reconsider its prior decision or rescind its prior decision, it did not take any such action. A motion for reconsideration under Robert's rule has to be made at the same meeting when the action was originally taken, and a motion to rescind is allowed unless action has been taken in reliance. But there was no motion to rescind that prior approval of the information plan, which means that approval still valid as we stand here today.
Are there any questions?
No,
All of that is in your written.
The only thing that's not in the written is the point about the motion for reconsideration and the motion to rescind, not having the debate.
Presentation by zoning administrator acting on behalf of the township board.
I think it's pretty clear that there's no argument that there's a need for a new reclamation plan. Even the planning commission conceded as much when they required a new reclamation plan within 6 months as a condition of a special land use permit renewal. Simple solution to all of this would just be for the applicant to submit an updated reclamation plan. I think the argument at this point lies in the fact that the planning commission can't approve a reclamation plan that they haven't yet received. This report is submitted on behalf of the Millington Township Board. Again, this report has been already submitted to you, so I'm going to read it in part, but it is a lengthy report. The Township Board has appealed the Planning Commission's February 2025 decision to approve a revised reclamation / site plan submitted by Tri-County Aggregate for their mining operation. The Zoning Board of Appeals is asked to determine whether the Planning Commission exceeded its authority under the Millington Township zoning ordinance and the Michigan Zoning Enabling Act by approving this plan. To properly evaluate the Planning Commission's actions, it is essential to understand the distinction between a site plan and a reclamation plan, as both serve different legal and functional purposes under the Millington Township zoning ordinance. A site plan is a comprehensive drawing and set of specifications that depicts how a property will be developed and used, including layout and structures, access roads, drainage, parking, landscaping, and compliance with zoning requirements. Site plans are governed by Article 17 of the Millington Township zoning ordinance and must be reviewed and approved prior to initiating any land development or special use activity. A reclamation plan, in contrast, applies specifically to mining and extractive operations. It outlines how land disturbed by quarrying will be restored upon completion of the extraction process. This includes engineered grading, slope stabilization, backfilling, topsoil restoration, and revegetation. Reclamation plans are governed by Section 5.03C and D, and is required component of any valid special land use permit specific for quarrying. A reclamation plan is not a substitute for a site plan and vice versa. A reclamation plan is a supplemental document that is tied to a broader framework that is defined within the site plan. As such, a reclamation plan may only be considered valid if it is tied to an active and approved site plan and special land use permit. There is an approved site plan, there is an approved special land use permit. It's only the reclamation plan that's in question tonight. The original special land use permit for the Tri-County aggregate operation, along with an accompanying site plan and reclamation plan for the Cedar Lakes Estate Development. And that's the term, or the title that's been given to the reclamation plan, Cedar Lakes Estate Development, was issued December 2nd, 2005. Following the issuance of the original special land use permit, Tri-County Aggregate was sued by Southern Links Trailway Management and by Millington Township. In 2007, a settlement was reached that resulted in a revised site plan. On May 10th, 2007, the Planning Commission approved the revised site plan and reclamation plan for the Cedar Lakes Estate Development with specific conditions. On October 10th, 2012, the Planning Commission approved a 10-year extension of the Tri-County Aggregate Special Land Use Permit. However, there is no documentation that a new or updated site plan or reclamation plan was submitted or approved in conjunction with this extension. As a result, the site plan and reclamation plan that were approved in 2007 would have expired by operation of ordinance in 2009, and the special land use permit itself would have expired in 2022. On August 12th, 2024, the Planning Commission voted to approve another 10-year extension of the Tri-County Aggregate Special Land Use Permit without recognizing that the prior special land use permit, site plan, and reclamation plan had lapsed. During that same meeting, the Planning Commission approved an extension of the site plan as shown, excluding sections D through G, acknowledging that those elements are variable and will change due to the nature of the business. This partial approval with exclusion reflects the fact that no updated reclamation plan was submitted for review. As a result, the 2024 special land use permit and site plan renewal process was procedurally incomplete and non-compliant with the requirements of the ordinance. On January 13th, 2025, during a public hearing on a separate request from Tri-County Aggregate for the resale of materials, attorney-client communications caused the Planning Commission to question whether the Tri-County Aggregate reclamation plan was in fact still valid, given that more than 17 years had passed since its original approval. The Commission tabled any further discussion on resale until a new reclamation plan was presented. On February 10th, 2025, the Planning Commission agenda included an item entitled Tri-County Aggregate LLC Proposal for Special Land Use Permit - approve or deny a TCA / Cedar Lakes Estate Reclamation / Site Plan. During deliberation, Commissioner Ed Maschke stated the intent of the board was to approve the original reclamation plan, that there were no differences. Chairman Zabit suggested the commission wait for a new site plan before voting. Commissioner Pletcher reasoned that if the new site plan did not include all the required items when it was presented, it could be denied at that time. In the end, the Planning Commission approved an extension of the 2007 reclamation plan for 10 years, with conditions. One of those conditions was that the current mining operation information, which we're assuming they meant an updated reclamation plan, would be turned into the Planning Commission by August 11th, 2025. Section 5.02C of the Millington Township zoning ordinance identifies extractive operations such as mining and quarrying as special land uses in the agricultural residential district. These uses are permitted only upon compliance with the detailed operational and reclamational standards as outlined in Section 5.03. Specifically, Section 5.03C, numbers 1 through 9, require that a new engineered and stamped reclamation plan be submitted with any application for extractive use. This plan must include the following: topographic map, final grading plan, topsoil and overburden handling, revegetation plan, phasing schedule, drainage and water management, end use description, engineering certification, along with additional information as noted in the ordinance. In addition, Section 5.03D states that no excavating or quarrying may begin or continue without the submittal and approval of a compliant reclamation plan. The Planning Commission approval to extend the 2007 reclamation plan for 10 years failed to comply with the procedural requirements set forth in Section 5.03C and 5.03D. Specifically, the Commission approved a reclamation plan that it had not reviewed, attaching a condition that the finalized version would be submitted within 6 months. This deferral in requiring the receipt of a new engineered and stamped reclamation plan is inconsistent with the ordinance, which requires all components of the special land use permit, including reclamation plans, to be reviewed and approved prior to permit issuance. This approval undermines the ordinance's intent to ensure thorough evaluation of potential impacts and enforceable mitigation measures from the outset, compromising the integrity of the approval process and creating future enforcement challenges. Township Legal Counsel affirmed that the 2007 reclamation plan should be considered expired, as it has not been implemented or materially developed in 17 years. Additionally, the attorney addressed claims that the original 2007 permit terms override current zoning standards. Counsel clarified that the current zoning ordinance, that is ordinance number 100 as amended, governs all ongoing or renewed land use activities. Any new or modified site activity, including revisions to the reclamation plan, must be reviewed and approved under the provisions of the ordinance in effect at the time of the application or the amendment. The original permit does not exempt the applicant from present-day requirements, particularly where no vested rights have been established through timely development. It should be noted that that attorney-client privilege document I believe has already been shared with you. And it can be discussed during closed session under the Michigan Zoning Enabling Act. But that document is not to be entered into the public record to preserve the confidentiality of legal advice provided to the body. The Planning Commission's February 10th, 2025 decision to extend the 2007 reclamation plan without requiring a new engineered and stamped reclamation plan tied to the valid site plan and special land use permit constitutes a significant procedural error and is in direct conflict with the Millington Township zoning ordinance. The 2007 plan has long since expired under section 17.06 and sections 5.03, and no action was taken to update or validate it in accordance with current ordinance requirements. According to section 17.06, site plan approval expires 2 years after issuance unless completed or formally extended. In this case, the site plan was formally extended by the Planning Commission. While reclamation plans are not given a fixed expiration period, they are only valid when supported by an active special land use permit and site plan. Once either of those approval expires, the reclamation plan automatically becomes null and void. Compounding this issue, the Planning Commission has repeatedly treated the site plan and reclamation plan as if they are interchangeable. This reflects a fundamental misunderstanding of their distinct legal and functional purposes. A site plan governs how a property will be developed, detailing the layout, infrastructure, and zoning compliance, while a reclamation plan governs how the land will be restored after the extraction is complete. These are not optional or redundant documents. These are separate, complementary components of an extractive land use approval, each governed by its own standards and protections within our ordinance. These facts demonstrate that the Planning Commission acted beyond its legal authority by extending an expired plan without requiring proper resubmission or review. The Zoning Board of Appeals is therefore respectfully asked to reverse the Planning Commission's approved extension of the 2007 reclamation plan. We also ask that the Zoning Board of Appeals affirm that reclamation plans must be reviewed and approved with a valid up-to-date site plan and special land use permit in full compliance with the current ordinance in the future. Any questions? But I'm going to come back to Emery's question that he asked during the first public hearing. You asked me if the board had reviewed my reports. The board had not reviewed my reports. However, the board did ask me to submit them to the attorney for review, and the attorney had reviewed both of my reports before they were presented to the Zoning Board of Appeals.
Okay, thank you.
I didn't think to mention it earlier. Any other questions?
Has there been any? The motion was for the site plan to be submitted, or reclamation plan to be submitted by August, some date in August, if I'm not mistaken.
Yeah.
Has there been any action? Anything received from Tri-County Aggregate?
Not to my knowledge.
Okay.
Any other questions?
Others? You do or no? Thank you.
Great. So the dates, Robert, are those dates valid? The date the appeal was submitted versus the date the decision was made? Didn't we set a timeline on that for 30 days after a decision was made, it has to be appealed?
Yes, the decisions.
Planning Commission decision. Is that what you're referring to?
Or
Yeah.
that was, I believe, February 10th. Yep. Let's do February 10th. In the appeal was February 21st.
Oh, okay.
But they did handle that quick. And once again, those are only the decisions that we are reviewing. We are not reviewing special land use permit.
Right.
Just the reclamation. Or, yeah, just the reclamation decision of the planning commission. I can only assume that there's going to be a similar motion for this as there was for The other special meeting?
I would think, yeah.
I would think that, and I think it would be incumbent on us to read all of those 77 pages before we come back, even to discuss, because we don't have everything in front of us that we can see.
I agree.
I would make a motion to acquire more information about conflict of interest.
Relating to trustee Jarzo.
Yes, yes.
Decision and Mr. Meeting.
Yeah, it has to be a postpone, right? You have to make a decision to postpone. We know the date that we can meet again after we review these documents. We don't have a date set yet.
We do not.
Yeah, I said it's gotta be-
Let's make it through this motion first, and then we can look at the date.
Okay.
A future meeting.
Okay,
Yeah.
What's that?
Right.
Is there a second?
Yeah.
So,
Can you repeat the motion, please?
yeah,
yeah,
I make a motion to inquire on more information on Ms. Jarzel's decision and the conflict.
okay,
Or-
so
or,
I did,
inquire
I'm
on
making
more-
a motion to
Bring back what I
postpone.
got.
I don't know if I can read what you said, but, all right, you're making a motion to require more information in regard to conflict of interest with Luann Jarzel. And, but we have to say to postpone a decision.
Yes.
That's to be
Yes.
part of that,
To
to postpone the decision on this matter.
postpone the decision on this matter.
Okay. Until
future meeting.
until future meeting, or until, yeah, until future meeting. Yeah, I guess we could word it the same way we worded before.
Yeah.
Yes.
If you'd like to read that one back, maybe
Well,
a cleaned up motion could be made.
it's a minute, so I find it.
While we're waiting.
Yeah.
I just want to let you know that there is a communication from George. He had a medical emergency, so that's why he's not here today.
Okay, so he's excused. But
So you can read.
I don't know where I wrote it. I don't know that I wrote the exact wording, but made a motion to delay the decision to the next meeting in order to
Consult the attorney, wasn't it?
yeah, consult the attorney as far as conflict of interest with Luann. So. Sorry, yeah, it's
Like,
okay. to
send your
accept it.
motion and maybe Ms. Gager can make it.
I would do that.
Um,
I will rescind my motion.
okay. A decision. I make a motion that the decision be postponed until a future meeting in order to gather more information for, in regard to conflict of interest with Luann Jarzel.
I will second that.
Roll call. Close.
Yes.
Bazansky,
Yes.
Gager,
Yes,
Bernard, yes. Agreed. Would we like to, okay, so motion to close special meeting?
I'll make a motion to close the special meeting.
Moved by Krasinski, seconded by Close. All right, we'll do a roll call. Hager,
Yes.
Close,
Yes.
Krasinski,
Yes.
and Bernard, yes. Okay. Motion to re-enter our regular meeting.
Wait a second, did we vote on the motion to postpone the meeting? Or did we just write it? I don't think we.
Let's make, I'm. Thank you.
Motion.
If we didn't, let's get it on record right now, so
Okay, because I don't think we did.
we're sending the motion to close, and who made that motion?
Mrs. Kager.
Hager, would you,
I move that,
would you?
that a decision be postponed until a future meeting.
Can you please rescind the motion to close the?
Okay, I will rescind the motion to close.
I'll second. All in favor?
Aye.
All right, so let's go back to your motion. Thank you for catching that error.
Okay, I make a motion that the decision on this matter be postponed until a future meeting in order to gather more information regarding conflict of interest with Luann Jarizel.
I'll second that.
Motion by Hager, seconded by Zansky.
Yeah.
Okay, we'll do a roll call on that.
Mr.
Kern. Close, I'm sorry. I was reading and speaking. So Close, Zansky,
Yes.
Hager,
Yes.
and Bernard, yes. Okay. Motion carries. Now may we have a motion?
I'll make a motion then, special meeting.
I'll second. So motion by Zansky, seconded by Bernard to close the special meeting. All in favor?
Aye.
Aye.
All right. VBA member comments. I'll reserve this, see if we can find my comment, see if we can find a date.
Do you need to approve George's excuse?
Oh,
Pardon?
yes, I would like to approve George Moore's absence as excused.
Okay.
That's by just by option of the chair.
Mhm.
Do we have calendars available to review a date, or do we do that separately?
Doesn't it depend on,
We would also have to reach out to the attorney and make sure that they're available.
Yeah.
right, and public notices?
Rest of the meeting.
So we've got to,
Well,
we
okay,
can't,
we'll withhold on that.
Yeah.
Okay,
and as far as training updates, some of us are going to Michigan Township Association training in Frankenmuth tomorrow. No.
Mhm.
Yeah,
Tomorrow.
it is tomorrow.
and let it be noted that there is to be zero deliberation about either of these issues outside of our public meeting. Right, no, we are all fully aware of,
Right.
but just want to state that out loud and for the public to hear that we are not to deliberate on that.
No conversation.
No conversation, no deliberation. That's the word until our next meeting.
Okay.
Okay, any others?
No.
Close? No. Okay. All right, motion to adjourn.
I will make a motion to adjourn.
I'll second that.
Great, all in favor?
Aye.
Aye.
Thank you all.
My work has got to begin. Third and fourth.
We're gonna save all these documents. This is turning. Okay.
You guys, I usually
No, I took a bunch of.
I have those. We have 77 pages.